When Hollywood came to Delaware. That's how Vanity Fair writer Dominic Dunn described the sensational trial in the Walt Disney Company shareholder derivative litigation. And certainly the 37 trial days from October 2004 to January 2005 featured testimony from some awesome star power. Directors of Disney such as film actor Sidney Poitier and former Senator and Nobel Prize winner George Mitchell, as well as Disney's CEO Michael Eisner and legendary Hollywood talent agent Michael Ovitz. But this narrative doesn't try to compete with Hollywood. There are no superhero battles here, just a battle of two Michaels, Eisner and Ovitz, former friends whose ultimately frustrating and expensive encounter at Disney set the stage for the resolution of many important aspects of modern corporate law and governance. Our story is told from the perspective of some of the lawyers and judges who contributed to that resolution. Greg Williams and Ann Foster of Richards, Layton and Finger, who represented most of the directors of Disney. David McBride of Young, Conaway, Starkett and Taylor, who represented Michael Ovitz. Seth Rigrodsky of Rigrodsky and Long, and Norm Monheit of Rosenthal, Monheit and Goddess, representing the stockholder plaintiffs. Former Chancellor William Chandler III, who presided over the trial and wrote some of the key court decisions. And finally, former Delaware Supreme Court Justice E. Norman Vesey, who wrote that court's first and critical opinion in the litigation.
So, Ann, if you could just, I think you probably had more involvement in this case than anybody, knew it better than anybody. Can you just give us a 30,000-foot level summary of the factual context?
Sure. So the Walt Disney Company was run at the time by Michael Eisner. The second in command at Disney was a fellow named Frank Wells. Frank Wells had tragically died in an accident, and Michael Eisner had, about a year later, decided to bring in Michael Ovitz as the number 2 at Disney. He got the approvals that he needed. Michael Ovitz came and was hired. And as Dave said, Michael Ovitz was somebody who was very familiar to the press. There was press coverage throughout his whole career at Disney, and it all ended in December of 1996, which was only 15 months after he'd started, with a non-fault termination, which was a term under his contract that meant he was going to get the benefits of the contract. And the lawsuit was filed the first weekend in January of 1997, so just a few weeks after the non-fault termination.
With a payout alleged to have been worth over $140 million for barely over a year's worth of work, the non-fault termination was a ripe target for stockholder plaintiffs.
Yeah, I think obviously this was a case that caught our attention because of the sheer size of the payout that was awarded to Mr. Ovitz and the relatively short time of his tenure at the company. So it seemed like a case for us that really called out for investigation and prosecution.
Prosecution, it turned out, in California as well as Delaware. And if it hadn't been for some quick footwork by the defendants, the case might not have been a Delaware case at all.
I remember it was filed here, and then the plaintiffs also filed, my recollection is in California.
Yes.
And they perhaps, and they decided for tactical reasons, presumably, they wanted to try the case in California. And for either we promptly, when we got wind of that, or we had already filed answers, so they couldn't dismiss as a matter of right. I guess they couldn't dismiss as a matter of right anyway, because it was a derivative action. So the first fight was the case going to stay in Delaware?
We had, when the case got filed, we were very worried that they would end up in California in front of a jury, which none of the defendants wanted. So we filed answers to the complaint because we were all cognizant of the fact that there was a famous case involving Texaco where a very large verdict had been obtained in Texas. So we filed answers so that they couldn't dismiss as of right. And then the first opinion we got was from the chancellor about whether they could voluntarily dismiss in Delaware to go to California.
In short, Chancellor Chandler wasn't too happy about the fact that the plaintiffs were bringing the lawsuit in 2 different jurisdictions at the same time. He said, One must wonder what theory of judicial efficiency or comity would promote a rule that encourages plaintiffs' counsel to file in multiple jurisdictions, force defendants to commit resources from coast to coast, and then allow plaintiffs' counsel at their own whim to move the lines of battle after they have already begun to form. The stockholder plaintiffs' attempt to pull up stakes in Delaware and pursue the case in California failed, a result with momentous consequences.
Is there anything that, with the benefit of all these years, you've looked back and thought maybe we should have played this a little differently?
Well, I am on camera. I think the first thing I'd do is probably file the case somewhere else. That's because I think if this case was tried in front of a jury, we would have had a different outcome.
Still, despite the size of the payment to Michael Ovitz, the case at its beginning didn't seem extraordinary to the defendant's counsel, or even to Chancellor Chandler.
When this case came to your desks, did you have any inkling that it would become one of the most celebrated cases in Delaware corporate litigation history? Ann?
I would say no, because yes, it involved a very famous company, but those of us who practice law in Delaware often work on cases that have to do with famous companies, and in many of those cases, you never meet any of the people who run the companies or board members. The case might go away for whatever reason, or it might be resolved at the pleading stage. There was nothing about this when it came in that made me think, oh, this is going to be something that's really going to be a famous case. Never thought it.
When you first had significant contact with this case, did it seem to you at all to be an extraordinary case or something in a significant way out of the ordinary?
Greg, I don't recall that I thought of it that way. I thought of it as it's another case, and all the judges on that court treat every case with the same degree of seriousness that it comes to every case. Yeah. So I didn't single it out as somehow special or different. I knew it involved, sort of this great American or iconic company. I knew that there was a lot of media attention to companies like that, and I knew that since it was in that business that there was even going to be extra attention paid to it. So I sort of had that in the back of my mind, but in terms of the issues and the principles that were in play in the case, I didn't really treat it differently or think of it differently.
Maybe that initial skepticism about the importance of the case was because the initial complaint in the case was put together quickly, without the benefit of access to non-public documents, using a demand under Section 220 of the Delaware General Corporation Law.
Do you remember, was there any discussion or consideration of making a 220 demand before you filed your first complaint?
I don't really recall that, I have to say. I wasn't at the firm at the time. I think back at the time, the notion of asking for books and records before you file a derivative case was something novel. It wasn't something that the court had really spoken to. And it was something that, at the time, there was more of a notion of the first one to file a lawsuit would get a lead position in the case.
And in short order, the defendants moved to dismiss the complaint, arguing under Court of Chancery Rule 23.1 that the complaint failed to impugn the loyalty or independence of the Disney directors, and failed to show facts demonstrating that the court should not defer to the directors' decisions about Mr. Ovitz's compensation.
I think we thought, look, this was a board that's got a lot of outside directors. It seemed to be a complaint that was appropriate for a Rule 23.1 motion to dismiss. We thought we would go ahead and file and see how that would go. And I assume you guys came up with the same theory on your own?
Absolutely, sure. And it succeeded. The case was dismissed on that first go-around.
Motion was granted, and a pretty routine decision from Chancellor Chandler.
Legally routine, maybe, but certainly colorful.
It had the memorable introduction about the size of the Disney cruise ship, that regardless of size, referring to the size of Ovitz's termination package, if an object can float, it can float. And so he drew an analogy there to the size of the Ovitz payment and said, the fact that it's a big payment doesn't mean that we're somehow going to change our jurisprudence. We're going to protect directors, and he granted the motion to dismiss.
The plaintiffs took an appeal from that decision, and that's when things started to get interesting.
So the whole Supreme Court process, whereas the Chancery process had been pretty straightforward in terms of briefing and argument, the Supreme Court proceeded in a little bit different way because, number one, we had the Council of Institutional Investors came in and filed papers because one of the things about the Chancellor's opinion was his discussion about different defendants, and the Council of Institutional Investors was annoyed with the fact that some people might be viewed as independent for certain purposes. So they wanted to come in and file a brief, and the Supreme Court allowed them to do that. So we had that additional aspect of things. And then we also had two oral arguments. We had an initial argument, which was in June of 1999, and then they decided to go en banc, and we had another argument in September of 1999. So when the decision came out, we already had a little bit of a different path than usual.
The Delaware Supreme Court didn't see it as business as usual either.
Probably not. I think we looked at this case as a very important case in terms of its facts. And it was a close case, as we said in this opinion, because it involved so much money, and it involved a process that was not clear in terms of what the Board of Directors did.
Still, the Supreme Court took a dim view of plaintiff's complaint.
And it also involved this complaint that the Chancellor had dismissed that was a mess. It was, we wrote in here,
Yeah.
the complaint consisting of 88 pages and 285 paragraphs is a pastiche of prolix invective, and it is permeated with conclusory allegations of the pleader and quotations from the media, mostly of an editorial nature, even including a cartoon.
Nevertheless, the Supreme Court was troubled. The sheer size of the payment to Ovitz, as alleged, pushes the envelope of judicial respect for the business judgment of directors in making compensation decisions. So, the court took the unusual step of affirming the lower court's dismissal of the case, but at the same time sent the case back to give the plaintiffs another chance to submit a better complaint.
It was an unusual decision from my perspective at the Supreme Court level, and we'll talk to Chief Justice Veazey about it. The court largely agreed with the reasoning of the court below, but decided to give the plaintiffs the ability to replead and directly encourage them to use, quote, all of the tools at hand, which we know refers to the ability to seek books and records under Section 220.
The court was very troubled by this case because of the magnitude of the dollars involved and the lack of clarity about the process that they used, and certainly the complaint didn't help. So we were very reluctant to affirm the dismissal with prejudice, but we were very concerned about the fact that we almost never refer the case back to articulate it with a dismissal without prejudice, but that's the direction that we went. And you can see that Justice Hartnett wrote a concurring opinion in which you probably got the flavor that there was a lot of concern about the case, whether it should go forward or not. And so as we tried to do, we tried to come up with a unanimous decision. We had a unanimous decision, and we all thought at the end of the day this was a good way to resolve it.
To take advantage of their new lease on life, the stockholder plaintiffs did exactly what the Supreme Court suggested. They used their Section 220 statutory rights to demand non-public records about Mr. Ovitz's hiring and firing.
So tell us about the 220. Was the production extensive?
No. So that was probably the rest of 2000 and into 2001. Got a 220 demand, looked for documents, and this was really a time before email had really exploded anywhere near the way it has now. So you had paper files. I think there were maybe 2 emails produced in the whole case, maybe 3. And so there were paper records. The Walt Disney Company had very careful, very complete paper records. So in terms of meetings and that sort of thing, there were materials, but If I remember correctly, the production was maybe about a foot or so of materials that got produced.
And those materials made all the difference.
As it turned out, they did, in fact, use 220, and they wrote a complaint that was much different than the complaint that you focused on back in 2000. Among other things, they learned that while they had pled that the board had approved the no-fault termination of Ovitz, which allowed him to get his full termination severance package, in fact, the board hadn't acted at all as a board with respect to that termination. And so they found that out through the 220. They amended their pleading, and then that fact that the board, qua board, had not acted with respect to the no-fault termination was one of the key facts that really drew the chancellor's ire when he wrote his opinion on the next motion to dismiss, where he denied the motion in really pretty critical terms, critical of the defendant's behavior, saying many, many times in the opinion, if these facts as alleged are true, this looks like bad faith to me. This looks like a conscious disregard of duties. And so I think that the Supreme Court strategy of directing the plaintiffs to 220 to see if in fact they could put forth a complaint that was viable and that would present tribal issues did in fact work.
The strategy turned up some remarkable documents, especially some letters written by Michael Eisner that would loom large over the trial because they suggested that Disney could have fired Ovitz for cause, which would have avoided paying most or all of his enormous severance benefits. Mr. Eisner wrote to some fellow directors, "Ovitz seems manic and is ill-equipped to lead the Walt Disney Company, because, he is emotionally and mentally not appropriate for the task. The biggest problem is that nobody trusts him, for he cannot tell the truth. The results would be disastrous if he stayed." In a letter written but not sent to Ovitz, he questioned your number of secretaries, the out-of-control renovation of your office, your attitude toward costs. And finally, "I do not think you really understand or like or are capable of managing a public company in the Disney style."
When you then got the next complaint after the 220 demand and the plaintiffs had reviewed a lot of documents, do you remember your reaction to it? Did it seem to you to be materially different, materially stronger than the first complaint you had dealt with?
I do remember that, and it was decidedly different, in my opinion. The second complaint was much more thorough and careful. They had gotten documents, they had gotten minutes of the board meetings and the comp committee's meetings, and to me, it was a much stronger complaint. It was not filled with as much just rhetoric that the first complaint I thought had been filled with, but actually had detailed, what the meetings were, what happened at the meetings, and how much time was spent at the meetings, and what was actually in those minutes of those meetings. So the complaint I did feel was just dramatically different from the first one, and that played a large role in why I came out differently on the second complaint.
The plaintiff's new complaint made the defense side pay attention, and there were some unsuccessful efforts to settle the case, but the defendants persisted with efforts to get the case dismissed.
We had some settlement discussions, and I can remember that being in New York at the Milberg Weiss offices in October of 2001. So we must have gotten to a point where we were getting pretty serious about settlement discussions. I can't remember if they'd given us a draft. They might have given us a draft complaint at that point. And I should just mention, because it's a derivative case, of course, you can't settle it by having a payment from the company. So the two sources were from the individuals or from the insurance company if you were going to settle it. Obviously, the individuals, your client included, didn't think that they'd done anything wrong and didn't want to contribute to a settlement. So the insurance company was the primary source for any funds then, and we were not able to get them to contribute to get it settled then. When we saw the complaint, we could see that there was a lot more detail, but again, we thought we would go ahead and move to dismiss to see whether we could at least try to get some of it dismissed, if not the whole thing.
As it turned out, that strategy may have cost the defendants some extra heartache and money.
Nowadays, I think it's fair to say that as the law has evolved, defense counsel are maybe more thoughtful than we were 20 years ago about whether to move to dismiss cases because of decisions like the one we're going to discuss in a second, where you lose the motion to dismiss and the judge says things or paints a picture in that opinion that you fear will make it difficult for you to settle the case or prevail at trial.
There were actually 2 decisions, if my memory's correct, on that second motion to dismiss. The first decision was a decision basically denying the motion to dismiss and suggesting that I think the way the court put it was some targeted discovery be taken on certain issues. And the issue arose, well, should we move for re-argument? And we had quite a debate as to whether we should move for re-argument. And I think we made the mistake of moving for re-argument. And it was that motion for re-argument that produced the second opinion that was much more hurtful to the defendant's position than the first opinion was. Because the first opinion made it sound like, well, we just need some more facts here. Why don't you go out and get the facts for me?
One thing that everybody agreed on was that Chancellor Chandler's opinion denying the motion to dismiss the new complaint cast the Disney directors in a harsh light.
I was struck by some of the language, and I'll just read a little bit. He summarizes the allegations of the complaint and says, "These facts, if true, do more than portray directors who, in a negligent or grossly negligent manner, merely failed to inform themselves or to deliberate adequately about an issue of material importance to their corporation. Instead, the facts alleged in the new complaint suggest that the director defendants," and he italicizes this, "consciously and intentionally disregarded their responsibilities, adopting a we don't care about the risks attitude concerning a material corporate decision." And the opinion is chock full of that type of language. So as you go about discovery, do you have a sense of optimism, foreboding, or just general uncertainty?
So I'll tell you, it's funny, and we'll get to this, when we won the case, all these people said to us, "Oh, I knew you guys would win. I knew your clients would win." But a lot of those same people in May of 2003 and June and so on were saying, "Oh, you're really in a jam. That opinion, that was pretty brutal. You're really, really in a jam."
And so now you had this more complete complaint, and it goes before the chancellor on another motion to dismiss, and very different outcome. He denies the motion. Do you remember reading his opinion and your reaction to it?
Well, again, the reaction was a very positive one. The chancellor had a reputation, at least amongst us folks on the plaintiffs bar, of being somewhat cautious in his rulings. We used to say that on a preliminary injunction, for example, if you brought a motion for a preliminary injunction to enjoin a deal based on a lack of disclosure or some problem with the board deliberation, the chancellor would often not grant that motion. So when he granted and basically reversed himself, denied the motion on the second motion to dismiss, we were very encouraged because we thought it was a very significant victory for us.
And it was a strongly worded opinion,
Yeah.
if you recall. I mean, there were many portions of it that read as if, to me anyway, that read as if he had made up his mind, or at least was inclined to think that, in fact, there had been bad faith here. And if you recall, he also, at the same time that he issued that opinion, he entered a scheduling order, which brought the case to a very prompt trial. Which was unusual at the time, and sort of, I can tell you, it sort of, sent shudders down the backs of the defense attorneys, because this seemed now to be a judge who was in a hurry to get to trial on this, and didn't seem too favorably inclined to our view of things.
Once Chancellor Chandler made it clear that the case was going to trial, it was full steam ahead.
We got a very clear message from the chancellor about what he thought about the status of the case, and it was pretty clear to us that we were going to be going forward to discovery. And then things happened really quickly over the course of the next few weeks. It was sort of almost every few days something new happened where were we going to be doing summary judgment? Were we going to be having targeted discovery? You know, what exactly would be happening? And I remember that we were before him here and there, you know, every other week, and all of a sudden, I think we had a discovery cutoff of June 15th. Now, this is going from in February thinking we were going to have a motion to dismiss oral argument coming up, to then no more motion to dismiss argument, we're off to the races, and we have a discovery cutoff of June 15th. And I can tell you at the time we were representing all of the defendants, individual defendants other than Ovitz. Because of the motion to dismiss stage, you could do that, and you know, many cases that's happened. And all of a sudden, I had to go get everybody's documents, respond to the discovery, start preparing everybody for depositions. And so I can remember pretty vividly March, April, May, June, all the months of that year.
Well, you know, and a really unusual aspect of the opinion that to me reflects just how unhappy the Chancellor was with how things have progressed. At the end of this opinion on re-argument denying the motion to dismiss, he writes as follows: "The practical effect of this ruling is that defendants must answer the new complaint, and plaintiffs may proceed to take appropriate discovery on the merits of their claims. To that end, a case scheduling order has been entered that will promptly bring this matter before the court on a fully developed factual record." He had entered that order sua sponte, which set a very prompt discovery and trial schedule. I don't think I've ever seen that before, and I think it reflected the court's attitude.
So what was Chancellor Chandler's attitude?
I particularly noted at the end of the opinion, you said, and by the way, I've entered a case scheduling order that's going to bring this to trial promptly. That was pretty extraordinary, wasn't it, to do that?
At the time it was. Now it's pretty routine, I think.
Yeah.
But I think at the time it was unusual to do that. It was a very deliberate effort on my part to send a signal that this case had already
Been knocking around for a long time.
Yep, had already grown a little bit of some whiskers around it, and I wanted it to get on quickly. I also thought that doing that, I was always hopeful that people would sit down and reason together, maybe compromise and find a way to resolve the case. And so I thought that by signaling that this was now, we were on the road to a trial and it was going to happen, would help that process.
Yeah.
The Chancellor tried another tack to encourage settlement. Instead of conducting the trial in Wilmington, Delaware's population center, which is close to a major international airport, he ordered that trial convene at the new Sussex County Courthouse in more remote Georgetown, Delaware. Remote from a major airport, maybe, but not from the attractive beach community of Rehoboth Beach. In short, the threat of conducting a trial in Georgetown didn't work.
To be quite honest with you,
Yeah.
I had moved the case from Wilmington to Georgetown for a couple of reasons. One of the reasons was that I thought it would help move people more quickly, that they would be uncomfortable being further away from home, further away from their home offices. They would be wanting to get back home, back to their offices, instead of being in this little county at the southern end of Delaware. And so part of the reasoning was that I thought that would help prompt things and move things along. It turned out, I think, to be the wrong prediction, because I think, in fact, people actually enjoyed it.
We had a wonderful time.
And, you know, you got to go home and walk along the beach at the end of the trial each
Exactly.
day and eat at some very nice restaurants.
We took walks in the evening, and sometimes we'd look in and see Seth and others, you know, lounging around, and you seemed to be having a good time, as the defendants did. It was one of the dirty secrets of the Disney trial that actually being down in Georgetown for a couple of months was not hard duty. It was an enjoyable experience.
And having the trial in Georgetown certainly didn't keep the media away.
There are lots of high-profile cases, as you say, Ann, that come across our desks here in Delaware. How did this become, you know, the sort of trial of the century, to use a trite phrase in Chancery? How did it become such a big event?
Sidney Poitier.
What do you mean by that, Dave?
Well, he was a director of Disney, and he was going to be examined at the trial. He was deposed, and it was, I remember everybody was just focused on when was he going to testify, because everyone wanted to see him testify. And as I recall, he was a star in the courtroom.
And what's your thought?
You know, there were so many people who were public figures, as you say, who were involved with this. And so it wasn't just Michael Eisner was a public figure. Michael Ovitz was said by the media to be the most powerful man in Hollywood when he was hired by Disney. And he enjoyed a relationship with the press, I think it's fair to say, had quite a relationship with a lot of members of the press, so that probably whetted their appetite. And then you had so many other people who were themselves well-known. Roy Disney, Walt Disney's nephew, was on the board. George Mitchell, who was famous for, you know, his political life.
Negotiated peace in Northern Ireland.
Yes. A lot of other people who were each in their own area, very well known people. And so I think when you put all those things together, for whatever reason, the media just became really fascinated by the narrative.
Tell us about the media. Had you ever been involved in a case with this type of media attention?
Absolutely not.
And so you must have had the same experience we did, particularly in the early stages of the trial, when you would arrive at the courthouse and it was as if you were at least a B-level star, because there were a dozen photographers or so snapping the pictures.
I was always amused by one particular incident. I got tired of running the media gauntlet on the way to the courthouse, so one day as the lunch recess was winding down, I decided that I would leave earlier than the rest of the team, and I figured I would be ignored. And as I approached the courthouse, one photographer jumped out from under this awning that they had there to protect them from the elements, and he sort of got in my face and took maybe 10 or 12 pictures of me walking into the courthouse without saying a word. And I just wondered to myself about the conversation that would occur that evening between this photographer and his editor, which would be something like, well, who is this guy? And the photographer would say, I don't know, just some guy with a briefcase.
Had a suit on.
Yeah.
Yeah, it was really hilarious. Dominic Dunn was in our hotel. And so he would be sitting and sort of pretending to just be eating, but in fact he'd be trying to listen to whatever conversation was happening next door.
In the swirl of media attention, the lawyers set about developing their own stories of the case.
How were you going to get over the bad faith hurdle? Because that had to seem like a pretty high hurdle to get over. I mean, do care is hard enough. You've got to show gross negligence. Now you've got to go a step beyond, and none of us were quite sure exactly how far beyond you had to go, but it was clearly going to be more hard than do care. So what was your strategy for doing that?
The bad faith element of this case was really focused on Eisner. That Eisner had engineered the hiring and then engineered the firing to save face, basically to use company funds to paper up the challenges that he had with Ovitz, to paper up the issues he had with him, and to avoid, a personal embarrassment by what happened. And so we thought that we could show that he reached out to his friend, who he acknowledged was a friend of his for 20 years. He hired them without really any input from any other members of the board, at least initially. I don't remember. There were several candidates that they looked at to replace. I forgot who it was who unfortunately passed away. Mr. Wells, I guess, who passed away. And so we felt that he basically brought his friend aboard without proper supervision by the board, but without a robust process and without vetting. And then when everything went south, it was really an effort by Eisner to protect his reputation from diminishment. One of the things that we thought was some of the best things that was there was a draft report prepared by Price Waterhouse that someone had gone through and did a report taking into account Ovitz's expenditures and expenses. And we thought that the document stood for the proposition that Mr. Ovitz had basically taken money from the company for his own personal use. And this all goes to the issue of whether did the board, did Mr. Eisner, did Mr. Litvak, the person who supposedly researched this, have a basis to say that Mr. Ovitz can be terminated for cause. And if he had been terminated for cause, then he wouldn't be entitled to the payout that he received. So we thought that was a very damning document, which the chancellor said was hearsay and wasn't admitted into evidence. But there's that, and also, as you had mentioned, the Eisner notes. Mr. Eisner at various times referred to Mr. Ovitz as being a psychopath, totally incompetent. He was described he was described by one of his confederates that he would act like a wounded animal if he had been fired from the company. He was there is a memo where Mr. Eisner said that Mr. Ovitz had displayed erratic behavior and had pathological problems. So again, all of these things, not to denigrate Mr. Ovitz or to say anything about Mr. Eisner, but that we thought that, wow, with unequivocal words coming out of the chairman's mouth about second lieutenant, like pathological and statements like this, we thought, wow, I mean, why couldn't this person...
You don't see documents like that
You don't
very
see
often.
that, and why
Yeah.
couldn't a person like this have been terminated for cause?
Right.
So we thought we had a really strong case.
Counsel for Mike Ovitz had a very different view.
There were two claims. One was a claim that it was a breach of fiduciary duty to enter into the contract, and a claim was a breach of fiduciary duty to terminate him without and not for cause. I never thought much of that first claim on the contract because, from our perspective, it was arm's length negotiation, and we knew how much money he had made before he was at Disney, and we knew what he was going to make at Disney was largely offset of what he was giving up.
This guy was the most successful agent in Hollywood by leaps and bounds.
I mean, he was probably making more in his agency. I mean, not only was he an agent for stars, he was actually producing movies. So he was quite wealthy. I think he went to Disney thinking this was a one-in-a-lifetime chance to become, ultimately perhaps, CEO of a major American corporation, an iconic corporation. So if he was, I never thought much of the claim it was a breach of fiduciary duty when they entered into the contract. And my big question was, did Ovitz want to leave or did he want to stay, and was he forced out? And subsequently, I learned through the discovery process and through consulting that he wanted to stay. And to me, that changed the complexion of the case completely. I think on that, what to me was the critical issue. Did Ovitz want to go or was he forced out against his will? I always thought that if the court concluded that Michael Ovitz was forced out against his will, and all he received was the contractual compensation he was entitled to if he was forced out early, that it would be that at a gut level, if the court wasn't going to hold Michael Ovitz accountable for this alleged overpayment, that it was unlikely the court was going to hold directors who were disinterested in the decision liable for any part of the payment. So my attitude was, if we can convince the court, and I thought we could because I thought it was true, that Ovitz didn't want to be terminated, and it really had a, I don't want to say a devastating effect on his life, but it was very hurtful to him both at a personal level, professional level, and a monetary level. I don't have any doubt that he would have much preferred to stay on at Disney. That if we could prove that, then it would be difficult for the court to hold anybody else responsible for what Ovitz got.
So how did the defense plan to deal with Mr. Eisner's letters that so viciously criticized Mr. Ovitz?
There's a line in here that I remember thinking, well, how are we going to deal with this in the trial? The quote, "The biggest problem is that nobody trusts him, for he cannot tell the truth." So this is from the CEO to two directors. And remember that the company paid Ovitz this $140 million because the company did not attempt to fire him for cause. And I always thought that the best claim that the stockholders had was that if in fact this guy was a pathological liar, which is the import of this letter from the CEO to two directors, why wouldn't you fire him for cause and save all that money? This
That's
is
Eisner's letter,
Eisner
right?
letter to Irwin Russell and Ray Watson. And then there is a draft letter that Eisner never sent to Ovitz. Am I right about that, Ann? I think he never sent it. And it's a letter written at about the same time that confronts Ovitz with all of his failings in the eyes of Eisner. And Eisner wrote this on a plane, decided that he would not send the letter, and shortly thereafter, Ovitz was terminated. So these documents are, at least in my experience, unique documents for a defense team to have to deal with, because you knew that Michael Eisner was going to have some very tough cross-examination to have to deal with.
Our biggest problem was that Eisner had written all sorts of memos that impugned the work of Ovitz. Now, frankly, I think Eisner had written those memos because he previously had, after Frank Wells died, my recollection is he had difficulty working with a second in command. My recollection is he went through a couple of other, at least one other person, and there was some criticism of him in the media for not being able to work with people. And so I thought that he was writing these memos, not so much because he wanted to make a case for the plaintiffs, but because he was trying to justify why he was now getting rid of yet another person as second in command. Now, those memos created problems for us, but we never really believed that anybody would. We didn't believe those memos were true, and we didn't believe that the plaintiff would be able to prove a cause for termination. But for us, the animosity between Eisner and Ovitz supported the story that Ovitz didn't want to leave, but it also supported the story that Eisner was after Ovitz, that what Eisner was saying about Ovitz wasn't really true.
Perhaps the most significant tactical decision in the case was the defendant's choice to have Michael Ovitz, of all their many witnesses, testify first.
The other defendants called us and said, we think Michael Ovitz ought to go first. And our first reaction was, oh yeah, because none of your people want to stand up there initially. And our, at least one person on the team, their initial reaction was, no, we don't want Ovitz to be up front right at the beginning. But then someone suggested maybe it was critical that Ovitz be up front right at the beginning. And that was because we didn't want the court to be hearing evidence like this letter about what a terrible person Michael Ovitz is, and sit through what we then thought would be weeks, it would have turned out to have been months, of testimony of people who were criticizing Ovitz. So we thought it was going to be important to get Ovitz on the stand and to establish roughly three things. One, that he didn't want to be terminated. Two, that none of the criticisms leveled at him in these letters were true. And three, and this was the most delicate part, that Eisner had a reason to mislead about Ovitz's performance. And we had a thread that was, given all the relationships, was really more art than science, for sure. But part of it was the fact that these were two strong personalities, two very ambitious people, and they just didn't get along. And we wanted to convince the court, and I think we did, that Eisner's criticism of Ovitz wasn't really credible, because there was a criticism born out of an animosity that arose between them for other reasons.
By all accounts, the defendant's tactic of having Ovitz testify first worked.
I'll tell you a little trial story is, Ovitz was on the stand, I forget, for a couple of days?
Several days, yeah.
And at the end of the last day, I happened to be in the back of the courtroom, and the bailiff was there. Rocky Justice was the bailiff's name. It was a name of quite notoriety.
His actual name
Is
was, in
Rocky.
fact, Rocky Justice. Yep.
And I was standing in the back of the courtroom as we were, I think because I used to occasionally go out to where the reporters were in the lobby of the courthouse. There was a room where the reporters sat and they watched the trial on a TV screen. And every now and then one of us would go out there and try to make sure they were understood what was being testified to. And I think it was at this part of the examination we were talking about stock options. So I went out to where the reporters were to sort of explain to them what was going on. They were absolutely, they did not understand it at all. I'm not sure after I was done they understood it either. But anyway, I was in the back of the courtroom, and as the examination was about to come to an end, Rocky Justice turns to me, he goes, "I'll tell you something. I never in a million years thought I'd feel sorry for that guy," referring to Michael Ovitz. And when he said that to me, I thought, we are going to win this case. Because that to me was what it was all about.
Well, I remember my role during his testimony was to object on behalf of our clients, the outside directors, let's just call them. And I remember listening to Ovitz's testimony and thinking, this guy believes to this day that he could come back to this company 10 years later and make it work.
Yeah.
That he really thinks it could have worked, and he thinks today that he could come back and work at the company and be successful. Now, that may have just been all what he was trying to sell. I don't know, but it did convince me.
No, I think it was true.
The stockholders' lawyers didn't agree with Rocky Justice, but ultimately Chancellor Chandler did.
I thought Ovitz brought to bear all the things we had seen before in his deposition and what we'd read and heard about. He was a very flamboyant guy. We thought that he was bending the truth in several respects. I remember thinking that they didn't really score any points, and I thought it would really be great. It was great for us, for the Chancellor, to actually see him in person and testify in person and judge his credibility. I mean, you have to recall that one of Ovitz's, or I shouldn't say one, his main theme in all this, and we talk about the camps of defendants, his theme, which we thought was actually amusing, was that he was a victim, that he had been victimized by Disney and by Eisner, that he really came in and he tried to do his job the best he could, and that because of the culture and because of Eisner in particular, he wasn't allowed to succeed.
Yes.
And we found that, frankly, from the evidence that we saw, we found that like just play acting and really just role playing as the victim. So we thought, great. When he came into court and it was a whole media circus and he did his thing, we sat there thinking, wow, that's really not credible, the story he's weaving. But I guess we were wrong, because to a large extent the Chancellor did credit a lot of his testimony.
Another tactical decision by the defendant's lawyers was to put on the witness stand all of the Disney directors who were physically able to come to Delaware.
We had some witnesses who were elderly, who did not have strong recollections, who hadn't remembered a lot in their depositions. We decided to bring them all to trial, everybody who could testify. Talk about that decision.
Sure. So we had 17, I guess there were 17 individual defendants. We had 13 clients. We had one client who had a medical issue and just was not going to be able to testify. But we thought, if you have people who were potentially going to have a judgment for $140 million entered against them, plus interest, and had been going on for a while, we wanted those people to all be able to come in and have their say, because we thought that when the Chancellor heard them talk, he would not be able to conclude that they had violated their fiduciary duties, that he would conclude that each one of them had a different background and a different approach to this, and so we wanted them all to come and testify.
I remember well, and this I think goes to what you were saying about the decision to call everyone, to give them their chance. We thought they were good people, and we thought that if the Chancellor looked them in the eyes, that it would be much harder for him to conclude that they had acted in bad faith, because we knew in our hearts they had not acted in bad faith, that they had done what they thought was right.
The key witness in this group was Irwin Russell, who chaired the Disney Board's Compensation Committee.
Irwin became really the the key witness in the case. We knew he would be. He was the chairman of the comp committee. He had negotiated Ovitz his agreement. He was a close family friend of the Eisners. And he was an unusual person with voluminous notes. And did a masterful job in putting Irwin on and using Irwin to, as lawyers like to say sometimes, carry the water. He carried the water of the entire chronology of the transaction, both aspects, the coming in and the going out, so that these other witnesses who maybe weren't quite so strong in recollection didn't have to carry water. They could just come in, make their point about why they did what they did, why they thought it was all appropriate, and then get off the stand. So, and what was your strategy with Irwin and his hundreds of pages of handwritten notes?
So Irwin was a really great guy. He had a really interesting background. He had worked, he'd been a lawyer for quite a long time. He'd done some work in the Eisenhower administration with the Wage Stabilization Board. Then he had gone to New York and worked in private practice, and then he'd worked as general counsel for, I think, Elektra Records. He had done work for Bob Banner Production. He was involved in setting up some of the things to do with Roots being a television program. I mean, he had had quite an extensive background in the entertainment industry. He knew the music business well. He knew the television business. He had done some things. I think he had a consulting contract with Warner Brothers at one point. So he had this very deep entertainment background experience, which made him a terrific lawyer for Michael Eisner. And he was a note taker. He and I spoke the same language. We both do that kind of thing. And we loved to try to work together to figure out exactly what happened when. So when I first met him to review his documents, to produce them, I saw that he had hundreds of pages of handwritten notes. And I defended his deposition, and we went through all of those to try to remember exactly what happened when and refresh his recollection, and then put him on at trial. And as you say, we had met all these people. We knew they were good people who had intended to do the right thing, and it was a matter of telling their story. But Irwin had a special ability to put it all together in terms of context and chronology. And
his
so,
notes gave him a contemporaneous roadmap.
yes.
Mr. Russell certainly came across well to Chancellor Chandler.
And you had Irwin Russell testify for a few days.
Yes.
You know, he was the chairman of the comp committee, and my partner Ann Foster took him very meticulously through volumes of handwritten notes about the process. And I think that to me was it may be the last trial I'll ever see where a fiduciary had such extensive handwritten notes. What do you recall about Irwin's testimony?
Well, only that it was meticulous, and he was a very careful and thoughtful man, I thought, who had been, in my judgment, put in just an intolerable situation. To be the guy who's who's Eisner's personal lawyer, who's negotiating with Ovitz, and answering to the comp committee. I just thought it was a difficult thing to have asked him to do. But he came across as a very credible witness. I thought he was very credible and very careful and meticulous. It's interesting now because I'm often asked in my new life, what do you think about directors or fiduciaries who take notes, extensive notes? And I'm always, be very careful. If you take really good notes,
yes.
And I think he did.
Irwin Russell's diligence also paid off in responding to the perception that another member of the Disney Compensation Committee, Sidney Poitier, was careless because he handled the Ovitz hiring decision while on a yacht in the Mediterranean Sea.
One of the defendants was Sidney Poitier, who just happened to have been on a friend's yacht when he was called to ask about the hiring of Michael Ovitz.
Crucial.
It was a very crucial time. And the plaintiffs, as you can imagine, in the press had a lot to say about that. And there was some suggestion that maybe the phone call never happened, or if it did, it was a 30-second phone call. And I can still remember, Irwin, of course, always said it was a long phone call. There's no question it was a long phone call. And we were a few weeks before trial, and I was in his offices, and he said, yeah, it was a long phone call. I know it was a long phone call. In fact, it was such a long phone call that when I got the bill, I sent the bill to the Walt Disney Company to be reimbursed. He said, I don't usually do that, but it was a really long, really expensive ship-to-shore phone call. And he said, I might still have a copy of that receipt. Now, we had searched his records that were the Disney records, but his office administrative records, there wasn't any reason to search those because we didn't know that they would contain anything. He went off and he looked and he came back and he found a cover letter that he had sent to the right person at Disney with a copy of the phone bill, and it had the date, it had the time the phone call started, and it had the time the phone call ended, and it was something like a 51-minute phone call.
I was going to say about an hour.
Yeah.
And you know, so we produced it that day to the plaintiffs who weren't happy to see it. But, you know, again, the contemporaneous record that Irwin had, and that was a really crucial thing because you can think as a judge, oh, somebody was on a yacht, how much was he paying attention? Well, he paid attention for 51 minutes. That's a pretty long call.
Anyway, Sidney Poitier also came to testify in person.
And let's talk a little bit about the biggest celebrity in the trial, Sidney Poitier. The courtroom had started, it was packed at the beginning of the trial for the first couple weeks, and then it had started to thin out. And then when news came that Poitier was going to testify, it packed up again. So tell me about putting him on.
Sure. So I'm a believer when you put a witness on the stand that you have the person tell his or her story. It doesn't do any good to try to have somebody tell somebody else's story because, you know, just like when you train young people to do something, when you're under stress or you're in a difficult situation, you always revert back to what you really are. And so with every witness, the witness tells his or her background the way it is. And with him, there had been a lot of criticism that he was in the entertainment business but hadn't necessarily had a business background. And what I wanted to do is explain that he had a business background in the entertainment business and give his story so that maybe he wasn't used to contracts like Michael Ovitz's in the corporate world, but he had the equivalent in the entertainment world. So for example, there was a situation where he was making a picture and the director was hired and had a contract, which was very common in Hollywood, that was, you get the whole contract even if we fire you. And very early on, I think maybe 2 or 3 days into filming, it was clear that his vision for the film was really not the right one and he was going to have to go. And he got fired and he got paid his whole contract. And so part of the direct that I did for Sidney Poitier was to tell his life story. And again, with that, I wanted the judge to understand that, because good faith was really going to be at issue here, I wanted him to understand who he was as a person, what his background was, and how hard he had worked in so many ways to get to the point that he had gotten. And I knew that if the judge heard all of that, he would understand that there's no way that this man would have done something that wasn't in good faith. So I had him tell his whole background, which is incredible. And then his entertainment career included, you know, stories such as the one where the director had been fired and had gotten his whole contract. And the plaintiffs were complaining about why I was going through all of this, and I know that they thought I was just doing it to try to dazzle the judge. That wasn't it at all. It was part of his whole story. And I'll tell you, then the chancellor cross-examined him and asked him some questions himself, which didn't happen much during the trial. The chancellor pretty much was letting the lawyers be the ones to do it. But Chancellor Chandler had several questions for Sidney Poitier. And when he excused him from the stand, I remember thinking to myself, there is no way that Chancellor Chandler is going to find that Sidney Poitier breached his fiduciary duties. I just knew it right at that moment.
The defendant's witness lineup also included Roy Disney, nephew of company founder Walt Disney, and he impressed even the plaintiff's lawyers.
Roy Disney, as I recall, was sort of the spitting image of Walt Disney. It was almost as if he were Walt Disney sitting up there. What do you recall of your cross of Roy Disney?
What I remember most about Roy Disney is that he was a true gentleman, an old school gentleman. He was someone who at that time was at odds with Mr. Eisner and the rest of the board. I believe he had some litigation going against him at the time and was threatening a proxy contest. So that was, there was some tension between him and the other defendants, I suspect, and we sought to exploit that. But of course, he wanted to make it clear that he felt he had done his job in connection with Mr. Ovitz's hiring and termination. One of the things I distinctly remember about Mr. Disney is that when his testimony was completed, he went around the courtroom and shook hands with virtually everybody. The court clerk, the court reporter, me. I think I'm one of the first people he approached. Yeah. He was a real gracious man.
When all was said and done at the trial, the strategy of calling all of the directors as witnesses worked just as the defendants' lawyers intended.
I think it was worth it, and it was a valuable thing to call every single one of them, even though their memories and recollections in some cases were very dim and faulty. But they all came across. I do remember thinking, these were all people who were honestly trying to do what they thought was the right thing, and they weren't doing anything that they thought was deliberate or intentional or harmful. They may not have done it the best way, but they were all, I thought, very credible and honest in the way they presented to me how this happened and what they remember of how it happened. So that's why I think overall it was a very valuable thing to bring every one of those individuals before the court. And again, like I said, I can't underestimate the effect of this. It humanizes them because they're just a name otherwise. Right. But when they come in and you see them and you hear them and you look at them on the stand and you look at their body language, a judge looks at all of that and can get a sense of, I can understand how they would have done what they did, and I can understand how this came to pass. So it was helpful to me.
Remember, though, all of these directors weren't all that important when it came to the critical decision to terminate Ovitz's employment without cause. The decision that resulted in paying him millions and millions of dollars in severance pay. That decision was ultimately made not by the directors, but by Eisner himself, relying on advice from Sandy Litvak. And it sure looked as if it wasn't a well-researched decision. But here's how two different key defense lawyers, Ann Foster and Gary Naftalis from the Kramer-Levin firm, representing Michael Eisner, responded.
Okay, I'll press you on one more thing, because again, from the outside perspective, I'm looking at this case and it's increasingly clear to me that at least where I thought the defendants were the most vulnerable was not on the hiring end of things, but was on the termination side, because the question was there cause for termination or not? And that had a huge financial consequence. And I would have thought that consequence would have been something that would have elicited more documentation, maybe even opinion of counsel, a written opinion of counsel or something like that. And yet, I don't think there was any such thing. And this, as I understood it, fell pretty much on Mr. Litvak's shoulders. What came out about how he addressed that, and how did you on the defense side try to portray that? Dave, not so much you, because that wasn't really your call, but on the defense side, how did you try to portray that to the court and explain why this hugely significant thing didn't get the kind of attention that we usually might have?
I'm sorry.
Well, let me just say before Gary explains how they dealt with that. This is part of the whole 8-year gap between the events and the actual trial. Sandy Litvak had called a lawyer in New York to talk about whether there were grounds to terminate Michael Ovitz for cause. That lawyer did whatever he did at his firm to talk to people, and they concluded there weren't grounds. He told that to Sandy. No question about it. There was no written opinion. There was no written advice. There was nothing at all. And unfortunately, because so many years passed by the time that lawyer's deposition was taken, he didn't have a memory of anything to do with that. So that complicated things. Gary?
Yeah, no, I agree with everything Ann says. Look, I think because of the passage of time and because there was no written opinion, so much of this depended on the oral testimony and the credibility of the witnesses, which really, for the most part, although there was some corroboration from other witnesses, was really Sandy Litvak and Michael Eisner's testimony. I think Irwin Russell, some of his testimony corroborated it, and a little bit of Stanley Gold's. But Look, the testimony was that after they decided that Ovitz really had to go and it hadn't worked out, that Eisner had multiple conversations with Litvak. He testified about, can't we not pay him? And Litvak would uniformly and repeatedly say, I'm sorry, just under California law, it's terrible. It's very hard to fire anybody for cause. And you can see it even from Michael Eisner. Michael Eisner would be persistent about things. That's his personality. He did not want to spend the money. And one of the kind of amusing parts of the testimony, which was documented in part, was, well, maybe we can avoid having to pay him by trading him to another company.
So the defendant's story was that Eisner didn't want to pay Ovitz severance compensation. And what made that story credible was simple human emotion. Both Eisner and Litvak just didn't like Ovitz. Here's how Mr. Neftelis for Eisner and Joel Freelander, a lawyer for the Walt Disney Company, explained the situation.
There's another factor, too, which was there was no love lost between Litvak and Ovitz. So I think Litvak's testimony was deemed to be highly credible, right?
Yeah, no, I think that's right. I even think at one point, because Sandy Litvak was one of the more important witnesses at the trial, I think, especially on the back end, on the termination, because I think he may have even testified explicitly this way. Look, given what I thought of Ovitz, of his performance and the person and the mess he created here, if I could have found a way not to pay him, I would have been first online. And it had a real ring of truth.
In fact, by the time of the trial, the atmosphere between Eisner and Ovitz even affected hotel arrangements.
Ovitz and Eisner had so much animosity for one another. They were never at the trial at the same time, and I think they made it a point that neither of them wanted to be in the same town with each other. But the animosity was so great that the hotel we were all staying at had one really fabulous suite. And I think Ovitz stayed in it at the beginning of the trial. And Eisner was upset when he found out that he would be in the same room that Ovitz had even been in weeks before. There was that much animosity.
After all the evidence went in, both sides felt optimistic that they would prevail.
We thought that we were going to win. We thought we had done very well. We thought that the court had received us very well. We thought the evidence was very strongly in our favor. Keeping in mind that it was Delaware. So I guess I should temper that by saying we thought we would have as good a chance as anybody could as a plaintiff's lawyer in Delaware. And so I was just telling someone the other day, I was the person, since I was in the Delaware office of Milberg Weiss, I was the person who went down to the court the day we were all called to get a copy of the opinion. And we actually had a party planned for that day up in New York. And, I don't want to say we were overconfident, but we were thinking this is going to be, a real celebration for the firm.
The defendants' lawyers were at least as confident that they were going to win.
So let's talk a little bit about assessment after trial. Were you both optimistic in the period between trial and receipt of the decision?
I would say that I was optimistic, although, again, very worried because the amount of money that they were seeking, joint and several liability, there were some defendants who might have been able to absorb that, but the vast majority didn't have that anywhere near that kind of personal resources, and it was going to be personally devastating. So I was very worried about them, even though I felt good about how the trial had gone.
I felt really good about how the trial went, and I felt like we were going to win.
And indeed, the defendants did win. Here's how the Chancellor explained how he came to see the case.
I do want to get the Chancellor's take on the witnesses that he saw, particularly Eisner and Ovitz. I mean, you saw them both. They testified for multiple days, I believe, and they were obviously central to the case. So what did you walk out of the courtroom thinking about after you'd seen them?
So I think the very, very first witness was Michael Ovitz, if I recall correctly.
On the defense side.
Yep. And I think that's where the story needed to be told, frankly. The story needed to be told from his perspective. and from Michael Eisner's perspective. And much like Gary's just saying, I think both also had a desire for the story to be told because I think they wanted redemption in a way for their reputations about what had actually happened. Both gentlemen were very articulate witnesses on the stand, and both, as I mentioned earlier, both Mr. Ovitz and Mr. Eisner told very plausible, I thought, incredible stories. I thought the lawyers who were doing the direct examinations did a terrific job of letting them tell what actually had happened. And once you listened to both of them tell what had happened, it became, to me, self-evident that this was just a bad marriage from the very beginning. This was an effort to bring in someone who had an enormous ability, but not right for this company, and who was offered a great deal of money because he was leaving a great deal of money. He was the founder of Creative Artists Agency. He was over a 50% owner of that company. He was making on the order of $25 million a year in salary. He had booked commissions that were going to pay him over the next 4 or 5 years, probably another $200 million. So he was giving up a lot, and he negotiated hard for a contract that protected him in the event something didn't work out. And unfortunately, things didn't work out. And that was the story that unfolded in front of me with those two witnesses. And as the opinion explains later, it fit the other stories that were told by the other directors who came later, whether it was Sidney Poitier or whether it was George Mitchell or Roy Disney or whoever. The stories made sense, and they contradicted the factual portrayal that the media had bought into and that the plaintiffs had sold so hard in the complaint. That was the mismatch for me.
Once the post-trial ruling for the defendants came out, all 174 pages of it, the plaintiffs' lawyers were disappointed, but both sides expected that it was likely to be affirmed on appeal.
When you got the opinion, what was your reaction to it?
I was certainly disappointed. We put a lot of effort into it. As I said earlier, I did not think there was any substantial evidence that meaningful consideration had been given to the fault versus non-fault termination issue. Whether that arises to the level of bad faith, which is necessary to substantiate a claim, I suppose is debatable. But I think if there was something about it that disappointed me most was the amount of credit that was given to the testimony that was presented in support of the assertion that had been seriously considered.
And tell me your recollections of the argument, if you have any.
My one recollection is that I came away from it concluding that the Supreme Court was not sympathetic to the issues we had raised. And of course, it's different at the appellate level because you have findings of fact to deal with. There had been a long trial, and the Chancellor's opinion certainly evidenced a close consideration of the record that had been developed before him, and the Supreme Court was surely going to show that considerable deference.
Did you think that the opinion was vulnerable on appeal?
Personally, I thought that we didn't have much of a chance on the appeal. The Chancellor had done a very good job going through all of the facts, making his findings. It would have been hard to say that there was an abuse of discretion or that even on a de novo standard that he could be overturned. We thought that maybe a panel of the court would see the facts differently than the Chancellor had seen. But, again, there's deference to the notion that he was there in this long trial. And maybe to a large extent, the length of the trial, all the documents that were allowed into the record, except for the few that I mentioned, cut against us because we couldn't argue that he failed to consider an important piece of evidence or hadn't considered certain facts.
Perhaps the only person who was nervous about the appeal was Chancellor Chandler himself.
You had an interaction with the Chancellor about his having watched the appellate argument.
Yeah, it's a great illustration of the wonderful sense of humor that Bill Chandler has. The appeal was argued in late January, and a few weeks later on President's Day weekend, we were both guests at a destination wedding on Paradise Island in the Bahamas. And at a pre-wedding party, we were standing on the beach having a pleasant conversation, and in the course of that I said, Chancellor, did you happen to watch the argument of the appeal? And he said, yes, I did. It was rather like watching my own autopsy. I didn't like it very much.
As it turned out, the Delaware Supreme Court saw things just the way the Chancellor did, particularly on the question of the validity of the non-fault termination. Here's how Justice Randy Holland explained the outcome.
When we got to the second part of the opinion, which was the termination, the real legal question was, did Eisner have authority to terminate Ovitz, or was that something only the board could do? And we agreed with the legal conclusion that Eisner had the authority, but it was supplemented by the deferential standard of review based on the facts, because Litvak, who was giving the legal advice, really didn't like Ovitz. And Eisner, by that time, was pretty clear, wasn't enamored with him either. So you had two people involved in making this decision that they had to give him the money when, if they had a choice, they wouldn't give him the money. So if we decided that as a legal matter, Eisner had the authority to do the termination, it was supported by the factual record. And so as a result, there was the affirmance.
So when all was said and done, how did the lawyers in the case assess its significance?
In your mind, Norman, were the issues in Disney worth all of the attention? This became a mega case, trial of the decade. Was it that important a case?
It was significant simply because of the star power, some of the personalities involved. I believe that it did have some long-term influence on corporate governance. There was a lot written at the time about the inadequate corporate governance practices at Disney that were exposed publicly through the trial. And I read any number of articles later about how boards were reforming their own governance practices so that they would not appear to be doing what had happened at Disney. And my impression was that, and remains, that the case had some influence, some considerable influence on board practices around the country. And to that extent, I think it was a significant effort.
It was in some ways sort of chapter 2 to the book that Van Gorkum had started about giving the courts the ability to speak out about best practices. And we kind of knew this was coming. We knew the best scenario for us was we win, but that there would be lots of criticism in the opinion of the way that the board had conducted itself. In fact, there was. I thought the Chancellor was quite clear in saying this is not a blueprint to follow. Here we are in 2017. Have you done anything since that was quite as interesting or fascinating as the Disney trial, professionally?
Well, that's some other cases that were interesting, but nothing that was this big, this much attention.
I think that it's fair to say that for whatever reason, this case just captured the attention of the media in a way that I've not really seen happen since. I've had cases with well-known companies and people, and there'd be some media coverage, but nothing like this.
Yeah, and it did feel at the time, and I think it's proven to be true, that it was a bit of a once-in-a-career opportunity for Delaware litigators.
Michael Eisner left Disney shortly before the Delaware Supreme Court affirmed the judgment in his favor. Michael Ovitz kept his Disney severance compensation, although it was reported that he lost nearly that much money or more in his comeback effort, creating multimedia company Artists Management Group. But maybe that's just life in Hollywood, at least when it's not visiting Delaware.